Good evening. It is 7, so I'm going to begin. Welcome to the 2025 Constitution Day Lecture, sponsored by the CMU Political Science Department. Dr. Sine already kind of touched on this, but just a few reminders. If you could refrain from using your phone. I know some of you are taking notes on iPads, so that's totally fine. This will conclude before 8 p.m., so please stay in your seats if you can. And tonight, I have the honor of introducing someone who I know very well, but some of you may not be as familiar. My mother, Kristen Burks, Associate Circuit Judge of Macon County, will be giving a lecture titled, "A Constitution That Still Works, the Fourth Amendment and Cell Phones." Kristen was raised in St. Joseph, Missouri, and attended the University of Missouri-Columbia, where she received her BA in Spanish in 1996. In 1999, she graduated from the University of Missouri-Kansas City School of Law and began work in the Domestic Violence Unit at Legal Aid of Western Missouri. She later accepted a position as a Jackson County Assistant Prosecuting Attorney in the Domestic Violence Unit in 2005. And following an 18-month stint at home with her 3 wonderful children, she and her family moved to Macon County, where she worked as an associate at Briggs & Russell, LLC, before opening the firm Meisner & Burks, LLC, in 2010. Kristen worked primarily in the area of family law in her private practice, while also serving as the Macon County's Assistant Prosecuting Attorney and attorney for the Macon County Juvenile Office. In January of 2019, she took the bench as the Associate Circuit Judge for Macon County. She was re-elected to the position in 2022. Kristen has been married to her husband, Matt, since 1996, and they have 3 children, Sophia, Joe, and Stella. Her son, Joe, and her oldest daughter, Sophia, are currently students here at Central Methodist, and I would ask you to please join me in welcoming Macon County Associate Circuit Judge Kristen Burks.
All right. Thank you. All right. Thank you. Thank you all for being here. I know that evenings are precious. They're time to eat, time to study, time to sleep, time to be with your friends. So I appreciate those of you who are voluntold to be here. I know there's some school credit that's coming with this. Thank you to the football players. Congratulations on getting your win Saturday. We are going to be here Saturday, so I'm hoping number 2, maybe, second dub. That would be great. I want to thank Professor Aliou Sine and the Political Science Department for extending the invitation to be here with you on Constitution Day. September 17th is the anniversary of the delegates signing the U.S. Constitution in Philadelphia in 1787. It's also somebody's birthday. I said I wasn't going to say it. I'm so sorry. The Bill of Rights, which are the first 10 amendments to the Constitution, that was ratified by the states in 1791. And so tonight we're going to consider how this document, which was drafted and ratified over 200 years ago, is still relevant in helping us solve some issues that we face today. My hope is that as we consider the scope and value of the Fourth Amendment to our Constitution, you can put yourself in the role of a judge and consider how you might resolve some of the issues that I will be discussing with you this evening. Before I really get going, I don't know how the volume is. Can everybody in the back there hear me okay? All right, great. Okay, so as you can see, the title here is A Constitution That Still Works, the Fourth Amendment and Cell Phones. Oops. We're going to begin with some history and context. As you can read, in 1787, the framers created a system of government that was intended to last. And without the benefit of any actual foresight, the authors of the Constitution and the Bill of Rights had a really unique task. They were trying to develop and draft a document that would establish the rights and obligations of a government unlike any that had ever ruled any other nation. It really was a unique experiment, and one that, being untested, could endure through the decades and even through the centuries. I doubt that even the most forward-thinking of the Constitution's framers could have imagined how their principles and declarations would be challenged and applied in our modern society. But therein, we find the beauty and also the genius of the documents, the Constitution and the Bill of Rights, that modernity and cultural shifts cannot erode their value and their importance. So, what exactly does the Fourth Amendment guarantee to the people? The Fourth Amendment reads that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So that's the actual language of the Fourth Amendment. Now, why would the authors of the Bill of Rights want to guarantee that the government's authority would be subject to this type of limitation? Go ahead to the next one. The people who wrote the Constitution and designed the system, they fought a revolutionary war to get out from under the control of a brutally effective law enforcement mechanism. This is something that many people have a hard time understanding when they consider why someone might want to support the rights of criminals over the rights of the police. But the framers knew what it was like to be labeled as criminals, to have their houses and their businesses violated in the interest of maintaining order for the king. In this new government, the Fourth Amendment would require a search warrant based on something called probable cause. So our U.S. Supreme Court has defined probable cause for us, and I'm going to read for you a definition of probable cause that came out of a case called Bryan-Garr versus U.S. And when I read this to you, you may see why it is that attorneys get paid per word. Because this definition of probable cause is one that doesn't exactly roll off the tongue. Probable cause exists where the facts and circumstances within the officer's knowledge and of which they have reasonably trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that an offense has been or is being committed. That's totally clear, right? Everybody would know right off the top of their head what probable cause is. No, that's not a very helpful definition. It's precise, it's expansive, and I think that it does describe what is probable cause, but in my work as an associate circuit judge, I have developed a shorthand for probable cause when it comes to search warrants. If you don't know, a search warrant is an order from a judge that gives law enforcement the authority to come into a home, to search a vehicle, to search a cell phone, even to draw blood or take fluids from your body to determine whether or not you were intoxicated. So a search warrant comes to me through an affidavit, which is a sworn statement by an officer, a law enforcement officer. And in that document, the law enforcement officer has to, what we call, articulate probable cause. That officer has to state within the four corners of that document probable cause. And the way I look at it is it more likely than not that a crime has been committed? And is it more likely than not that evidence of that crime will be found at the place the police are wanting to search? So that's kind of the standard. Is it more likely than not? I think when we think of criminal actions, we think beyond a reasonable doubt. When a jury is determining something, it's beyond a reasonable doubt. But at the crime investigation level, it really is more likely than not. So that's the shorthand standard that I use. When a police officer comes to the house, it seems like these always happen in the middle of the night or late at night. They have come upon a crime scene and they need to obtain a search warrant to get inside. So they will leave one law enforcement officer at the scene. Another law enforcement officer will write up the probable cause statement and the affidavit. They'll come to my house. I will swear them out. They'll have to affirm, and then they sign the search warrant in my presence. or they sign the application in my presence, and then I review it. It has to be very precise. It's not just a yellow house on the corner of Main and 6th Street. They are describing specifically what type of porch it is, how many windows are in the front. Many times they will attach a photograph of the house, trying to be as precise as possible. If we are going to take steps to invade someone's personal home, we need to be as careful and as precise as possible to make sure that we are going in the right place for the right reasons. Okay. So, in our new government, the one with the Fourth Amendment, we have an impartial judge, not a police officer, determining whether or not there is probable cause and whether the facts justify a warrant to conduct a search. Something else I want to say, I talked to you about the four corners of the document for a search warrant. I cannot ask the law enforcement officer any questions. Whatever information I'm relying on has to be set out in that document. So unfortunately, there have been times when the thing to be searched is not specific enough, or they have not been able to tell me what is the connection between the crime and the thing to be searched. How do I know that there is a connection? How close in time is the information that they have? Are they relying on a confidential informant? Well, have they relied on this person in the past? Has this person provided information in the past? Sometimes the information comes from what they call trash pulls. Whether you know this or not, law enforcement will go around and check trash to see if there is any drug paraphernalia in the garbage. Well, when was the last time they did a trash pull? So these are all the things I have to consider. So what good is a rule of law unless there are consequences for violating it? The Supreme Court established the exclusionary rule, in which evidence obtained by the police in an unconstitutional manner would be excluded from trial. In other words, regardless of whatever good intentions the police had, or how heinous the crime was, or how obvious it seems that this is evidence of a crime, if it's not obtained properly, it cannot come into court. And as a judge, I cannot consider anything that cannot come into court under the rules of evidence. I can't just take a guess. I can't just make a leap. I have to have the evidence admitted properly. The Supreme Court, the U.S. Supreme Court, has developed and extended the exclusionary rule, which is referenced here, in three ways. So in a case titled Weeks versus the United States in 1914, the Supreme Court established the exclusionary rule and applied it to the federal courts. In Mapp versus Ohio in 1961, so this is like some 50 years later, the Supreme Court extended this rule, the exclusionary rule, to state courts, which is really most important because the bulk of criminal prosecutions happen in state courts. There are federal prosecutions, and I couldn't tell you the numbers, but the bulk of criminal cases occur in state courts with the police powers that the states have. And then finally, as with any rule, there are exceptions, and the exclusionary rule has its own exceptions. A few of these are the good faith exception. If law enforcement has a warrant they're acting on, they conduct a search, and there's an error in that warrant, but the law enforcement officer believed the warrant was valid, that evidence still may be admissible. There's another rule, exception called inevitable discovery. Evidence may be admitted even if it was obtained with an invalid warrant, if it would have been discovered anyway. Another exception is the independent source doctrine. Did law enforcement learn this information from a source apart from the place or thing that was searched illegally? So as you can imagine, courts must apply the principles of the Fourth Amendment to our technologically advanced world. I don't know what that picture is from. We're not dealing with that level of technology. I don't know what that is. As the government gains access to more advanced technology, we need to know, how does this technology affect the protections of the Fourth Amendment? In the 1960s, the Supreme Court identified the key inquiries. In other words, the Supreme Court came up with the main question that needed to be asked when it came to Fourth Amendment searches and telephones. And that is, what is the reasonable expectation of privacy? There was a case, Katz versus the United States, in 1967 that first broached this question. One of the first attempts of the court to apply the Fourth Amendment to these technological principles came in this case, and here the court established, as I said, the key point of inquiry in search and seizure cases. So in every case involving a search and a seizure in the Fourth Amendment, this same theme is going to come up. What is the citizen's reasonable expectation of privacy? So in this case, the FBI got evidence for a criminal case by attaching a listening device to the outside of a phone booth. What is a phone booth? Who here has seen a phone booth? Who here under the age of 20 has seen a phone booth? Okay, all right. So, there used to be these public telephones, and they were in this cool little box, and you'd go in and close the door, and you'd put in a couple dimes, then you could call somebody. But one, you had to know their number. Who knows anybody's number? Nobody. Two, you had to have money to get in there. And three, if you didn't put enough money in, they would cut you off. Well, the FBI did not get a warrant to put this listening device on the phone booth. Why not? Why not get the warrant? Do you think that the FBI believed they were all powerful and didn't need to abide by the Fourth Amendment? Maybe. Maybe they didn't care about individual liberties. Well, when we look at this case, we're sort of looking backwards. At the time, a more physical trespass. And when I say that, I mean traditional methods of getting in people's business, going into their home, going into their business, rifling through their papers, digging through their purse, more physical things. We don't really think of things being transmitted electronically. At this time, that was not considered a physical trespass. And so law enforcement wasn't worried about violating people's privacy. Here we have a very public venue, which is a phone booth, a location open enough that the FBI may have thought it did not qualify as we think back on the language of the Fourth Amendment, persons, houses, papers, and effects that were enumerated in the Fourth Amendment. In Katz, the court had to balance governmental power and individual interests. So the court in Katz wanted to come up with a new way of approaching the questions that modern technology would present. They did so by developing a new way of defining what is a search. Like I said, in the past, it used to be you're going into somebody's house, you're digging through their papers, you're opening filing cabinets. But now, the question would no longer be one, did the police engage in an actual physical trespass, or was this a public or private setting? Now the question was, did the individual who was searched or had their things searched have a reasonable expectation of privacy? If so, then whatever the government did or used to invade that expectation of privacy would be considered a search, and the Fourth Amendment would be applicable. All right. So the reasonable expectation of privacy involved two parts. First, did the individual have an actual expectation of privacy? Did they really think the thing that they had or the thing that they were doing was not for the public consumption? Second, are we as a society ready to recognize that expectation as one that is reasonable? I don't know. I think about often when you rent a hotel room, you are occupying that space. It is your personal space. Your belongings are there for 24 hours or however long. But, there are other people who have access to that room. The hotel staff has access to that room. If there were an emergency, law enforcement could come in. If there was smoke rolling out from underneath the door. So is it reasonable to have an expectation of privacy in a hotel room? I don't know. It's something we need to consider. Many people want to define search as any governmental effort to obtain evidence. and the CAT standard makes the question of a search more challenging to determine. The court ruled that Katz had a reasonable expectation of privacy by going into a phone booth and placing his call. Thus, what the FBI did was a search. Reasonable expectation of privacy creates a search. That leads to the second question. Did the FBI get a warrant? In this case, the answer was no. So the search was a violation of the Fourth Amendment. And when we talked about a violation, what happens when there's a violation of the Fourth Amendment? Can the government use that evidence against someone in court? No, it's gone. So, is there a reasonable expectation of privacy? Was there intrusion by the government into this reasonable expectation of privacy? If so, was there a valid warrant? So, before we judge the FBI too harshly in Katz, it's important to remember that the court changed the rules after the fact. Before Katz, their surveillance of the phone booth would not have been a search because they did not consider anyone in a phone booth to have a reasonable expectation of privacy. So, of course, they would not have bothered with the warrant. However, once the court changed the rules, can you click one more? Thank you. The FBI action became a search, and moving forward required a warrant. So let's consider a couple of more modern cases. And if anybody has any questions, feel free to raise your hand, or if I've said something that doesn't make sense to you, just raise your hand. All right. So our first modern case concerns the search incident to an arrest exception. So I had talked about requirements for a warrant. There are some exceptions to that. Exigent circumstances are one exception. If it appears that someone's life is in danger, law enforcement can enter into a building without a warrant to preserve life. Another exception is search incident to arrest. The police may search the person arrested and the area within his or her immediate control. So that would be anything within their reach, anything on their person. And as we think about this exception to having a warrant, can you all consider some reasons why it might be a good idea for law enforcement to be able to search someone right after they've been arrested?
Safety.
Perfect. Safety, exactly. Yes. Are there any weapons on this person? They always ask before they go in their pockets, do you have anything sharp in here that might poke me? Any other reasons we can think of? How about preservation of evidence? If you can imagine someone who's being arrested, who's not going to panic? I've read a lot of narratives where somebody's chucked something out of the window as they're driving down the road. People will flush things, they'll ingest things, they will do a lot to destroy evidence. So search incident to arrest is very important. So our county has a jail that was just built. We house people from several other counties. And every time someone comes into the jail, there's a sign that explains to them bringing out any kind of contraband in here, which would involve drugs or weapons, is a felony. The number of people who bring in those items, specifically drugs, into the jail might shock you. And the places that the folks will put those drugs would also probably shock you. And so search incident to arrest is very important for the safety of the defendants as well. We don't want someone in the jail who has consumed something that might be harmful to them while they're in custody. All right, so what about someone's cell phone when they get arrested? You know, the concerns that Clint brought up or that I mentioned, where the contents of the cell phone, do those pose the same concerns that we discussed in a search incident to arrest? I mean, it's not likely that a cell phone is going to create an issue of officer safety. I mean, I suppose it could be chucked at somebody, but not likely. It's not likely that something in that cell phone is going to be dangerous. But it is possible that it has evidence on there. So we're talking about not cell phones that remain on a person, but cell phones that are in the custody of law enforcement when someone gets arrested. So the reality is that all judges and courts do not necessarily answer this issue in the same way. Reasonable minds can differ. Different federal courts of appeals took different positions, as did different state Supreme Courts. Can we imagine why it might be a good idea for our nation's highest court to resolve this issue? Do you think if we have different rules in different federal jurisdictions, you can understand how that might create problems for federal law enforcement. You've got FBI or federal agents, marshals working in different jurisdictions in federal districts, and if the rules are different in each of those districts, it's going to be difficult for them to know how to proceed in cases. So having one decision by the U.S. Supreme Court to determine what would be an appropriate search of a cell phone is really very helpful. So in this case, the Riley versus California, after David Riley was arrested for possession of illegal firearms, his smartphone was searched without a warrant. In there, law enforcement found text videos and evidence linking Riley to a gang shooting a few weeks earlier. So when the case went up on appeal, so he was found guilty. The evidence was admitted at the trial. He was found guilty, and he appealed, which means that Mr. Riley asked for a higher court to determine whether or not the state court, the trial court, made the right decision. So a higher court looked at this, and it eventually went up to the United States Supreme Court. The attorneys for the defendant argued that the material was discovered in a search. His attorneys argued the material was discovered in a search without a warrant, and that was prohibited at trial by the Fourth Amendment. The government argued that all materials found in the course of a search incident to an arrest may be examined. But what Riley said was that cell phones are so different that a different set of rules should apply to them. They're such a unique piece of property that they need their own rules. Now, you may be tempted to see both of these arguments as having some appeal, and that's okay. Many times, both sides do have compelling arguments, and it can be a real challenge for the courts to determine what is the right answer. Where does the law lead us? So, you can be the judge. Did the warrantless search of the smartphone violate Riley's Fourth Amendment? How many of you think that the police violated his Fourth Amendment rights when they searched his phone without a warrant? Okay. How many of you think that the police did not violate his rights and they could search the phone without a warrant? Okay. All right. The court's decision was unanimous. The Supreme Court ruled that Riley's Fourth Amendment rights were violated. In other words, there should have been a warrant, and that the police should have obtained a warrant before searching the smartphone. Writing for the Supreme Court, Chief Justice Roberts argued smartphones were different and should be treated differently under the Fourth Amendment. He points out how different cell phones, you can go ahead and put those things. He points out how different cell phones are from other things that might be obtained in a search incident to arrest. This is a case where the court, recognizing technological advancement, and is looking to ensure that the Fourth Amendment continues to protect the individual and limit the government. So some of the differences pointed out. I mean, I bet there are many young people here who don't keep any records on paper, right? Everything's on your phone. You get all of your grades on your phone. You submit all of your homework on your phone or on your tablet, on your iPad. Sensitive, protected personal information, portals to remotely held private information. Roberts' decision is rooted in the Fourth Amendment's protection of houses, papers, and personal effects, and the places where we keep our most private information. So where is our personal information today? Like I said, it's on our phones. Roberts also pointed out that the justifications for a search incident to arrest weren't present here. There wasn't any issue with protecting the officer's safety. There wasn't any issue with protecting evidence that might be destroyed because the phone was in the possession of law enforcement. There wasn't any exigent circumstances, no emergency that they had to open the phone for. And once the police had the phone, it posed no threat to the officer, and the arrestee, the defendant, could not access the data to destroy it. So why not get a warrant? Roberts recognized the decision made it more difficult for the police to do their jobs, but he emphasized that the police could still act. Our holding, of course, is not that the information on a cell phone is immune from a search. It's just that it is instead that a warrant is generally required before such a search, even when a cell phone is seized incident to arrest. So the Chief Justice is acknowledging that this decision is going to make it harder for police to do their jobs, but that is the cost of having courts committed to protecting our Constitution and the Fourth Amendment. So what about other aspects of cell phones? They do more than just hold information. Can the government gain access to what we call CSLI without showing probable cause? So I think you all probably know that your cell phone, every time you use it, hits a tower and creates a record called a CSLI. Every time you text, the same thing happens. Every time you receive a call or text, the same thing happens. That's how your parents can follow you on that 360 app. But I also want to point out that even when you're not actively using your cell phone, when it's in your pocket, your backpack, in your car, it is also periodically making contact with these towers and creating these data points called CSLIs. So Tim Carpenter is our next defendant. He was a suspect in a string of robberies. Now, the facts in this case are very complex, and it would probably be a lot of fun to spend a whole hour really drilling down on this. But one thing to remember is that there is legislation called the Stored Communications Act, and that act allowed law enforcement to get a court order to gain access to these CSLI records based on a standard that was lower than probable cause. So remember when I talked about probable cause, it was like more likely than not, more likely than not. In this case, it's even lower than that. And the defendant argued that basically, hey, this information you're getting, it's a search. I have a reasonable expectation of privacy that this data being sent out by my cell phone is not going to be made available to the government just whenever they want it. It should have a warrant based on probable cause. So, Carpenter argued, reasonable expectation of privacy. When we have a reasonable expectation of privacy, what does that require? A warrant, right? All right, so the government gaining access to the records was actually a search, but it never obtained a search warrant. There is additional, let's see, I'm going to try and read this carefully. There is another federal statute which designates a customer's cell phone site location information as Customer Proprietary Network Information, CPNI, and it gives customers certain rights to control how this information is used. It specifically forbids a carrier to use, disclose, or permit access to individually identifiable information without the customer's consent, except as needed for the phone company to provide you with service. But the government argued that Carpenter willingly gave up his location to the wireless carrier, so he no longer had an expectation of privacy. They argue that the information at that point belonged to the cell phone company, not to the individual. And when the FBI got that information, since there was no reasonable expectation of privacy, there was no search. So, you be the judge. Did Carpenter have a reasonable expectation of privacy in this tower data, the CSLI, making the government action a search which would require a warrant? Any thoughts? How many think that he should have a reasonable expectation of privacy and there should be a warrant? All right.
I don't think the government get it from Indirectly, they get it from the cell phone.
Yes, they got it from a third party.
Third party.
Yes, yes. It's like somebody going and asking your mom something. I mean, she's going to tell him, right? She's not going to, yeah, she's going to give you up. Probably not my mom, though. My mom's here. All right. In a 5-4 decision in Carpenter versus the United States, the Supreme Court ruled the government violated the Fourth Amendment. Now, this was a 5-4 decision. Remember, in the last one we talked about, it was a unanimous decision, meaning all of the justices agreed. But in this case, it was split 5-4. That's as close as you can get. In my work, I've been asked to consider signing what is called a geofence warrant. Now, imagine that you have a crime scene in a rural area, or not even a rural area. We had a case in Macon where they found half a body that had been burned. It was half the body was sticking out of a fire, but half of the body had been burned. A rural crime scene, nobody around. A geofence, but there was no suspect. There was no way to know who had been in that area. I mean, there were no cameras around. It wasn't on a busy street. There was no way to know who had been in that area. A geofence warrant would obtain information from specific cell towers in a specific geographic area. So when I say geofence, I mean they would plot out the area, the towers that they wanted in a specific area, and get the cell phone data from that area for a pretty lengthy period of time. It could have been over a matter of a couple of days, or it could have been a matter of hours, but because they didn't know when the crime had occurred exactly and didn't know who had been there, they wanted a geofence warrant. Does anyone have thoughts on whether or not this is fair to sort of, after the fact, kind of trap people? And when I say that, I mean like after you've been someplace, someone can go back and pick out that data. We had, there's a little town in our county called La Plata, and someone had set a fire outside the school. They didn't know who had done it. I guess there were not cameras on that part of the school, but they wanted a geofence warrant for the streets surrounding the school for a particular time, to see who had been in that area. I mean, just by virtue of being there, you would have had your data searched by the government. I have not signed any of these warrants because I didn't believe there was a valid connection, or what we call a nexus, between someone's mere presence in the area and the evidence of a crime. So going back to what I said earlier, is it more likely than not that a crime has been committed, and more likely than not that evidence of that crime will be found in this search? You know, I'm always trying to weigh all of that. What is the connection between the crime and the thing to be searched? Is it strong enough to support probable cause? So once again, Chief Justice Roberts wrote for the Supreme Court. He wrote that Carpenter had a reasonable expectation of privacy from 24-hour surveillance over an extended period, and what the FBI did was a search. Once again, he wrote, I already said that. To conduct such an extensive and intrusive search, the FBI should have shown probable cause and obtained a warrant, and the failure to do so violated the Fourth Amendment. So I'm going to read you some of what Justice Roberts wrote so you can kind of get an idea of why he came down the way he did. Mapping a cell phone's location over the course of 127 days provides an all-encompassing record of the holder's whereabouts. As with GPS information, the time-stamped data provides an intimate window into that person's life, revealing not only his particular movements, but through them, familial, political, professional, religious, and even sexual associations. These location records really hold for many Americans the privacies of life. And he goes on to describe a situation that is almost Orwellian. Do you know what I mean when I say Orwellian? The book 1984, written by Orwell, it was written a long time ago, but it portrays a society where every aspect of our lives was surveilled. Every aspect of relationships was under scrutiny by the government. And he wrote that, moreover, the retrospective quality of the data here, in other words, the ability for law enforcement to look back, gives police access to a category of information otherwise unknowable. In the past, attempts to reconstruct a person's movements were limited by a dearth of records, so they would have had to leave behind some kind of evidence they were there, and the frailties of recollection, or somebody would have had to remember that they were there. With access to the CSLI, the tower information, the government can now travel back in time to retrace a person's whereabouts, subject only to the retention policies of the wireless carriers, which currently maintain records for up to 5 years. Did you all know that? I hope you also don't think your Snapchats go away, because I've signed a lot of warrants to get Snapchats. I just wanted to let you know that. Critically, because location information is continually logged for all of the 400 million devices in the United States, and this was like 7 years ago, I don't even know what that number would be now, not just those belonging to persons who might come under investigation, but the newfound tracking capacity, it goes against everybody. Anybody with a cell phone or a device who had been in that area would have had their information accessed by the government. All right. 4 members of the Supreme Court disagreed. It was a 5-4 decision. What they argued in their dissent, so most of the time when, how do we know what the Supreme Court decides in something? Do you have to be there? Do you have to hear them? No. What they do, they issue written opinions. It's like a written report of the history of the case, what information they use to decide it, and what legal precedent, what happened in the past that they relied on to make this decision. So an opinion usually has 2 parts. It has what the winners say, and then it has what the losers say. So there's the majority opinion, and then there's the dissent, which is the folks who were less than 5. And in this case, the dissent, they wrote, the FBI got the information from a third party, from the cell phone company. It wasn't the defendant's records that were being searched, and that this defendant had no Fourth Amendment interest, had no reasonable expectation of privacy in the records from the phone company. They considered the third-party doctrine. When individuals voluntarily give information to a third party, in other words, when you tell your mom where you're going and what you're doing, you no longer have a reasonable expectation of privacy, because you never know who this third party is going to be talking to. That's why when attorneys meet with people, you know, the attorney-client privilege, like the attorney can't say anything about what happened in here. If there's a third person in that room, a defendant brings their mom in or a friend or something, that expectation of privacy goes out the window. That other person can be called in to testify. That's a separate topic. Sorry, I'm getting off topic. But when you give your information up to a third party, you're losing that reasonable expectation of privacy, is what they argued. And the closeness of this decision really does remind us again, reasonable minds can differ. Additionally, what if the next time the police surveillance is much less extensive? You know, it was less than 127 days. Let's say it was just a matter of a couple of hours. Would that make a difference? Would the court still consider it a search that had to be justified by probable cause? Well, these issues of privacy and technology have been plaguing the courts, and I don't mean plaguing in a negative way, but the courts return to them over and over again. Justice Louis Brandeis wrote in 1928, the makers of our Constitution conferred as against the government. In other words, the people who wrote the Constitution gave us these rights against the government, the right to be let alone, which is the most comprehensive of rights and the most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. So, do we agree with Justice Brandeis? Was that too long ago? Does that not really matter anymore? Is that just too unrealistic for us to consider in a society that is driven by data? Not just the generation, but the sharing, the storing, the accumulation of data? I don't know. Justice Brandeis seemed to have seen the issue of technology and the Fourth Amendment looming on the horizon. His position is that whatever the means employed by the government, we always have to continue to use the Fourth Amendment to protect individuals and to curb government power. So, what's going on in Missouri? What's the Missouri court's position on this? Well, in 2014, it was actually the citizens of Missouri who made a change to our Constitution. You all may know or may not know that constitutional changes come from the people. They have to be ratified by the people. We've had some constitutional changes recently, and those would not have happened without being ratified by the people. The ratification amended the Missouri Constitution to extend protection to electronic communication and data. So the protection against unreasonable searches and seizures extended beyond persons, papers, homes. Oh, I'm sorry, Sophie, can you switch to the next one? Thank you. Okay, so here's the language from the Constitution as it reads now. You can see the bolded portions, and electronic communications and data, over and again, electronic data and communication. So all of the protections that were in place before have been made more specific and more ironclad with that language in our Constitution. Applying the wisdom of those who drafted the Fourth Amendment to our world of smartphones and electronic constitution is what has followed, thanks to Justice Brandeis and all the others who have worked to preserve our right to privacy. So, were Missouri citizens correct? I don't know. I think this issue is far from settled, and the debate is going to continue. But thankfully, as we've learned, reasonable minds can differ on these topics. So that is the end of the formal presentation. So